Welcome everyone to Memoir bonus session that I'm so thrilled to have two special guests today. The first being Devon Sivill, and I absolutely am so excited. It took me a long time to find somebody like Devon because where do you find somebody that is perfectly lawyerly, like Bill said last year, and also somebody that's passionate about the right for us to tell our stories. And when we are memoir writers, it is important for us to tell the truth. But with telling the truth, our truth, it could be different from somebody else's truth. It could be hurtful to somebody else. And so we're going to hear about defamation, slander, and libel, and how to protect ourselves, the definitions of those so that we're very clear. So Devon is a licensed lawyer in Ontario with a focus on civil litigation, defamation, employment law, human rights, administrative law, so much. And more important, like I said, he has the passion for stories that are told well and to support writers. And in order to do that in memoir, well, we need to have somebody and the information that Devon has. He is in your corner. Let's welcome him. And Devon, take it away and let people know if you want questions to wait until the end or if you want to take them during.
Sure. So thanks, Rusty. Absolutely thrilled to be back with you. See some familiar faces, which is great. I'm just going to take a minute here and I'll share my screen. I have some slides that might look familiar to some of you who may have been here last year. And I will say, in terms of questions, I'm happy to be flexible. I suggest that maybe because we're starting a little bit later than anticipated, maybe we'll wait to the end and then I'm happy to take whatever we have time for. I don't want to eat into Tina's time either. So let me just make sure. I think everybody can see my screen here. Excellent. See some thumbs up. Good. Good. So I'm just going to shift some things around here. Actually, let's do it this way. Stop sharing for a minute and then we'll move some things around so that I can look at you while I'm chatting with you.
Wonderful.
Sorry, give me just 1 second
And we
here.
can go past the top of the hour a little bit. I'll just let
Oops.
Tina know, and that's super fine. So, not to worry. But yeah, probably best to leave bigger questions until the end. But if something is burning away at you, then pop in and ask Devon while he's
Yeah. All
in the
right.
flow. All right.
So let me just see here.
Typical
So,
lawyer, he wants to see the miscreants and ne'er-do-wells that he's talking to.
well, hey, listen, I don't judge at all. Um, let me,
Now
you
that's
can
the
be
judge's job.
as miscreant like or as ne'er-do-well like as you wish. I won't judge. I like to say that I'm not on the clock. So, let me just see here. We'll share this. Hopefully this works. Awesome. You guys can see that. All good. Excellent. That's fine. I don't know why that's happening. Let's go. Sorry. Let's go. Start from beginning. Okay. All right. I think we're organized. So thank you for the grace while we figured that out. Um, so as Rusty said, my name is Devon Sivill. I am a licensed lawyer in the province of Ontario. I've been doing exclusively litigation work for about 11 years now. And so we'll talk a little bit more about me on the next slide, but I'm here today and happy to talk to you about defamation, libel, and slander. What is it, and how can authors, and for that matter, other creatives, protect themselves and their work? Because I have always believed and continue to believe that that work is so important. And so I'm really excited to share this knowledge. I think that knowledge is often the first step, both for creators and for the general public, in knowing what's out there and what risks it can pose, and also what we can learn from those risks in terms of just being better and more proactive as creators in the future. So happy to be back to talk about that. I'd be a really poor lawyer if I didn't start with a disclaimer. And the disclaimer is that the information that I'm sharing today is presented as general legal information and not legal advice. I know that we're dealing with multiple jurisdictions here, and so defamation laws are one of those areas of law that differ widely by jurisdiction. And so I'm going to give you some general information on defamation and defamation laws. But it's always wise to consult a licensed professional in your jurisdiction for legal advice specific to your situation. And one of the things that I have told Rusty is that I am happy to provide referrals. I do have a relatively extensive network. So if you are confronted with the need for advice on defamation related topics, I'm happy to provide referrals as need be. Um, I've been practicing as a litigation lawyer in Ontario since 2014. I opened my own practice, Devon Sivill Law, in October 2023. And as Rusty said, I focus on civil litigation, employment law, human rights, administrative law, and most appropriately for our purposes today, defamation. Um, and really, I've been seeing an upswing in defamation work in the last, say, 5 to 6 years. I think post COVID, we've seen a lot of very prominent defamation cases, both in Ontario and across Canada and across the U.S. as well. And you may have heard of a small time defamation case involving Johnny Depp and Amber Heard. And so, that's one that I think has really brought defamation law into the spotlight. Just a little note about my firm. We operate in a virtual first environment. So, one of the things that I'm really passionate about is making sure that legal services are as accessible as they can be. And so we really pride ourselves on going virtual first. We're able to do phone and Zoom services. We also operate in a largely paperless environment and cloud-based. So and I have clients throughout Ontario and actually with respect to my defamation practice all over the world now. And I operate at all levels of court in Ontario. Let's talk a little bit about what defamation is, and you can see that I've pulled a quote from the Frontier Foundation, which is an internet advocacy group around freedom of speech and defamation. I'm not going to read it to you. You can read it on the slide. But basically, when we talk about defamation, I think that there are three key things that we have to keep in mind. No matter where you are, what jurisdiction that you're in, defamation is basically dealing with the publication of information that has the tendency to lower the reputation of an individual within the eyes of a reasonable person. Okay, so that's step one in most defamation tests. And then I think it's important to draw a distinction between slander and libel because defamation as a word is used to cover both of those. They are sort of legal meanings and there are different bodies of law around each. So slander is verbal defamation, and libel is printed defamation. And I think for our purposes today, what we're probably going to spend most of our time talking about is libel because obviously as creatives, if you're putting the written word out there, there's a greater risk of printed defamation or libel to you. Um, again, I spent a little bit of time talking about what defamation is. Again, I'm going to repeat it because I think it's important for authors and creatives to know. Defamation is basically when somebody shares something about another person that tends to lower that person's reputation in the eyes of a reasonable person. Um, to be about the person who's claiming the defamation. So they have to clearly reference the plaintiff in a defamation action, and they have to be conveyed to more than one person. So if, for example, I say something that's defamatory to Rusty, but I don't, then there's no defamation action because you have to be able to disseminate that false information to a third party other than just the plaintiff. So on this slide, you'll see common defenses to defamation claims, and there may be some defamation defenses that are available in other jurisdictions that I haven't put up here. But these are the big ones that sort of are available to those confronted with defamation. allegations across jurisdictions. And I'm going to spend a couple of minutes just talking about each of them. So the most common one that we see is truth. And so truth, fortunately for authors and creatives, is an absolute defense to defamation claims. So if you're confronted with defamation claim and you can prove that the information that you have shared is true, that's an absolute bar to any further claim of defamation or against you. The tricky part is that in most cases, in most jurisdictions, there is what they call a shifting onus. So when you are the plaintiff and you're alleging that you have been defamed, um, in most cases, the plaintiff will need to show, and I say in most cases because there are some jurisdictions where it's the opposite way, but in most cases, the plaintiff will need to show that the defendant has done those three things that I talked about earlier, which is shared some information that will lower the plaintiff's reputation in the eyes of a reasonable person, communicated that information to about the plaintiff and communicated it to third parties who are not the plaintiff. So once that happens, then if the defendant in a defamation action wants to defend on the basis of truth, the legal onus shifts. And the defendant then has to show with evidence that there is truth to what was said. So I mention that now because there is a sort of a complex legal interplay, and this is why I always say that it's best to get legal advice from a qualified professional in your jurisdiction if you are ever confronted with these types of claims. But for our purposes today, I will say truth is almost always an absolute defense to any claim of defamation. So you should take heart because as long as you're telling the objective truth, you will be insulated to a large degree from claims of defamation, libel, or slander. Um, the next one that's important to talk about is privilege, and there are a couple of different types of privilege. But again, for the simplistic nature of our discussion today, I'll say that in certain cases, the disclosure of certain documents is necessary. So, for example, if you are providing as evidence things that were stated under oath in court, that can be a defense to potential defamation claims. Fair comment is a bit more of a complex one. Essentially, most the structure of most defamation laws really tries to acknowledge that folks have a right and an ability to share their opinion. And so fair comment is a bit of a nebulous defense, but essentially involves the argument that, look, I made a comment that's reflective of my opinion and it was made without malice. And in some cases, that can help defend against defamation claims. Innocent dissemination is one that we will sometimes see, although I'll say from my experience, if we're dealing with an issue of innocent dissemination, in most cases, um, in most cases that gets resolved before we ever get to the litigation stage of a defamation action, and basically that's where the potentially defaming party goes, oops, sorry, I didn't mean to share that information. I'll take it down, I will change it, and I apologize. And in most cases that may not defend against the defamation itself, but it will certainly be um, it'll certainly go toward action. And then finally, and this one is more complex, we'll get into it a little bit later, responsible communications on a matter of public interest. So, one of the things that I often see in my own defamation practice is so news organizations, for example, may publish that somebody has been charged with a crime, right? And there are sometimes situations where charges will have been withdrawn or what have you, and so that news organization then may get sued for libel, notwithstanding that they can also rely on the defense of truth. There's certain situations where they can say, look, we're a news organization. We are sharing information that is a matter of public interest, i.e., the commission of crimes within our local communities. And so in some cases, that will also serve to defend defamation actions. And I'm going to talk in a little more detail about anti-SLAPP laws, because when we talk about anti-SLAPP laws, we're really dealing with that sort of final point there on communications that are a matter of public interest. So, this is where I have had to do a little bit of digging. As I say, I am very familiar with the legal test for defamation in Ontario. I've also, because I know that we've got folks from all over, I've also taken some time to dig up some of the tests for defamation in some of the most sort of populous jurisdictions. So you can see we've got Ontario, we've got British Columbia, we've got the test in California, and you'll note that the testing in California is a little bit longer. There's some extra steps that you have to establish if you're going to sue for defamation. Um, and again, I won't go through them. I'm happy, Rusty, to share the slides if your folks want access to them later on. That's no problem. Um, I've also included New York and, of course, England and Wales, which is where most of this law originally comes from. So you'll note that really, again, we're dealing with sort of the same central themes, which is that somebody publishes something that is false, or has the tendency to lower your reputation in the eyes of the community. It's about you as the plaintiff, and it's conveyed to somebody other than you. So really, I mean, all of these tests have a different way of saying that, and there are some pieces you'll see where it talks about, well, you have to prove that you've suffered damages. That is a bit of a jurisdictional minefield, because in certain jurisdictions, Ontario being one of them, when defamation is established, legal damages are presumed to some degree. So then it becomes an issue of quantum of damages or amount of damages. In some other jurisdictions, you do have to prove the damages with evidence. So I will just render that as a caveat. And the other thing I'll mention is that in all of the cases that I've shown, the burden of proof for proving libel is on the plaintiff in a defamation action. So, um, that leads me to the meat and potatoes of why we're here today, which is, you're probably asking at this point, well, that's really scary. And so what can I do to try and avoid this minefield? So I've sort of distilled this into a number of points. I mean, there are other ones that I'm happy to chat with you later on about the specifics of your situation to the extent that I can. Generally, you always want to be truthful. And I mean, I think, in my experience, having worked with authors and creators in the past, I mean, nobody sets out to be defamatory. Nobody sets out to convey misleading information. But I mean, being truthful to the greatest extent that you can be is always going to be your first line of defense. Make sure that you fact check your claims. Try not to editorialize too much. We don't want to take the creative out of the creative process, but at the same time, you have to be careful that we're not sort of going down a bit of a rabbit hole. And sometimes, especially with what I like to call emotionally charged writing, we tend to want to look at it, and we're feeling a lot of feelings. So that comes out, on the computer or on the paper, depending on how you're writing. And that can sometimes mean that the comments that we make are broader, and in making those sort of broader comments, there's a question of whether all of that content is absolutely true. And so again, that's not meant to stifle you as creators, but I would just say, be truthful to the extent that you can. Use verifiable sources. Most of you as authors know that and know the importance of that. Um, to the extent that you can anonymize identities and factual details, I mean, this is something that we often see in large scale writings. So I think last year I used the example of Jody Wilson-Raybould's book Indian in the Cabinet, which I had recently read at the time. And of course, she was talking about some of the internal strife within the prime minister's office at the time. And so one of the things that she did was change the name of a lot of the involved staffers, and that really helped insulate her. I mean, obviously there was a whole other big argument that a lot of lawyers followed about cabinet privilege in the release of that book, but I will say that that kind of helped her a little bit in terms of trying to avoid some of those issues. So where you can, anonymize identities and factual details. And that's not meant to say that you need to give up creative control of your work or make it look like something that it's not. But to the extent that you can, it's always a best practice. Um, Work with your publication team and legal advisors. I cannot stress this enough. Your publisher, and for that matter, their lawyer or your lawyer, will always be appreciative if we can be proactive with these issues. It is really, really hard, no matter how much we as lawyers want to help our clients, it's really hard if we are confronted with this issue after it's become an issue, especially in the context of publication, because then you're dealing with publication deadlines and print deadlines, and now we might have to do a retraction or we might have to change things. So your publisher and their legal team will always be more appreciative if we can iron out these issues before the book goes to publication rather than being confronted with allegations of defamation after the fact, which in practice is probably going to lead to the book being pulled for a short period of time, some stuff changed, and then re-released. And we'd like to avoid that because obviously that creates challenges for authors as well. Um, be aware of anti-SLAPP legislation. If you are an author or a creator and you don't know what anti-SLAPP legislation is, you should. And that's one of the things that I'm going to talk about in just a minute. Um, and then, you know, if in doubt, and I don't love this point, but I feel as a professional, like I need to make it. If after taking all of those steps, you're still in doubt whether or not you're on the right side or skirting closer to the line on some of these issues, consider whether that individual is so central to your story that they absolutely need to be included or need to be included in the same way. And the great I think one of the great things that you all have at your disposals as creators is you have some level of creative control, right? And so one of the it may be a challenge when you're looking at this going, look, I want to write about this, but I think that might put me at risk of defamation or libel claims. And if that's what you're thinking, I mean, I guess what I would say is, you know, you have that ability within yourself to be able to look at it and say, okay, I have creative control here. Maybe I can tell the story in this way that's going to still meet my needs as the author and meet the general public's needs, but may also insulate me in a better way from defamation or libel claims. So that's kind of my nuts and bolts about the best practices for avoiding defamation claims in your writing. And now I'm going to get into what I hope won't be a technical discussion of anti-SLAPP legislation. Um, I will say that anti-SLAPP legislation, SLAPP stands for Strategic Lawsuits Against Public Participation. Many jurisdictions, and certainly all of the jurisdictions that were on my chart previously, have anti-SLAPP legislation. Um, what it's designed to do is protect expressions on matters of public interest. And so I'm not going to go into the test for whether or not anti-SLAPP will succeed in a particular case because it's very fact driven. But essentially, what happens in an anti-SLAPP motion, usually what happens in these types of situations is somebody sues for defamation, and then the defendant will bring a motion for an anti-SLAPP relief. And essentially, in doing so, what a defendant is saying is, look, there's no defamation here, but even if there was, this is a strategic lawsuit that's designed to prevent public participation or public dissemination of important information. And again, I don't want to speak to other jurisdictions, but I would say in Ontario, what happens is there's a specific legal test that the plaintiff has to establish on a motion like that, and then there's a legal test that the defendant has to establish. And if the defendant is successful in showing that it's a matter of public interest that's being conveyed, the lawsuit is then dismissed at that juncture. And oftentimes there is an elevated costs award to the defendant in those cases because the court will then conclude that the writing that was thought to be defamatory is actually in actual fact a matter of public interest. Um, so again, really important to know your anti-SLAPP legislation, and if you as an author or a creator don't know it, make sure you're working with a publisher or a legal team who knows that legislation. Um, my hope is always that none of my clients ever have to use anti-SLAPP legislation, because that means that no matter how strong their case is, if they've never had to use anti-SLAPP legislation, it means that they've never been confronted with a defamation claim. And so that's obviously the best case scenario for everyone involved. But no, I think one of the things that I find when I talk to authors and creators is that folks don't understand that this legislation is out here and it's designed to help insulate from frivolous claims of defamation, and it's designed to convey the message that there is this sort of desire within our respective society that people be allowed to talk about the things that are important to them, in a responsible way, especially when they deal with matters of public interest. So um, that's what I would say on that. And then lastly, I know I've given a lot of information. I just want to sort of end with a couple of other pieces. So most jurisdictions have abutting privacy laws to defamation. So if, for example, and I use Ontario examples, but I'll talk to you about, in general terms, if you're publishing things like health related information, there may be health related privacy statutes that you have to consider separate and apart from defamation. If you are talking about things like, and again, I'm just picking random examples. If your book involves, music or film or those kinds of things, you may want to look at copyright and rights ownership as to whether or not you can publish about that, because oftentimes copyright and rights ownership will include publications related to that piece of work that you're referencing. So, make sure that you're aware of those, because they're not really the subject of our conversation today, and I could do potentially a whole other conversation and presentation on those issues. But make sure that you know that they're out there and they may impact your creative choices separate and apart from any sort of concerns about defamation. And then the last thing I'll say, Ontario in particular has in recent years invoked what we call a tort law around publicity which places a plaintiff in a false light, which is separate legally from defamation. We don't have a lot of cases before the court on that tort in Ontario. Other jurisdictions have a similar tort, but even if you are pursued, with a defamation allegation, and you can successfully defend that, it doesn't mean that you are completely off the hook, because there may be other theorems of law that a plaintiff could assert liability under. And so again, always important to talk to a qualified legal professional in your jurisdiction. And the one thing I will say is this is becoming an increasingly specified area of legal practice. Um, so you really need to not just talk to the guy who does your wills or your real estate closings or what have you. You really need to get good legal advice on these things. You need to talk to somebody who knows what they're doing and practices in this area. Because if you don't, in my experience, these are not the law around these things, which is becoming increasingly complex year on year, especially in the information age and in the age of social media, if you're not talking to somebody who really has a good handle on what the law is, you're not giving yourself the best advice and the best tools to be able to protect yourself. Um, so I would just offer that as a sort of closing comment, and then I'll just say, I'm very appreciative to Rusty and to all of you for the opportunity to be here and talk about this stuff. I think that in my experience, a lot of times the biggest hurdle is making sure that folks know that this is out there, and I don't think anybody ever engages in defamation on purpose, but a lot of times it's just a an ignorance of the law. And so you are absolutely taking the first step by being here today. And I'm grateful for the opportunity. So I'm happy as always to take questions, and I will trust Rusty that you will give me the hook when we have run out of time.
I will definitely do that for you, Devon. This is awesome. It was really good to review this, and I wrote down some new things this time. I have some questions. I'm sure other people have questions. So either pop up the mic or put your electronic hand up or wave wildly to me with your questions. And if nobody, pops in with a question in the first 3 seconds, well, I'm going to go ahead and ask one on the behalf of one of the authors I'm working with who wanted to be here but can't. But that question can wait for a moment because I can always reach out to Devon. I also know I'm definitely going to reach out to you about a couple of sticky issues in my own memoir. So,
Of course.
yes. Okay, Barbara.
Well, I mean, it's complicated. I'm writing letters about my motherhood journey, and of course, my three sons are in it. And on one level, it's personal. I want to continue to have a relationship with them, but I also want to be honest. And there's some things they probably won't enjoy having me write about if they end up reading it, which I'm not sure if they will.
Sure.
But so it's very difficult. I mean, if I change their names, I I don't think that would, help. They wouldn't know
Mm.
who they are.
Yeah, it's a tricky situation. I think you know, again, this is where, and I don't mean to oversimplify the issue, right? But if the things that you're writing about can be verified as true fact, right? Then I would say that I never want to say there's never a chance that there wouldn't be a defamation allegation, but if you can verify very clearly with documentary evidence that the things that you're writing about are in fact true, the risk is much less to you, right? And um, I guess the other practical piece, and maybe I should have mentioned this in my presentation, is um, just because somebody could sue you for defamation doesn't mean they will, right? There are other circumstances that determine whether somebody decides to take that sort of sizable step. And so, one of the things that I'm always very cognizant about when I do this presentation for this and other groups is, I, you know, I appreciate that it's my role to think about the law, and I do that every day, and I do that all day. But the reality is, you folks have wonderfully creative stories that you should tell. And as much as the lawyer in me wants to be as proactive as possible, and may come across at times as saying, "Oh, you shouldn't say it because there's a potential risk of defamation." I mean, to some degree, I kind of think that that's like me saying you shouldn't cross the street because there might be a chance that you get hit by a car, right? Like I think for me, you can only do what you can do. And so in your case, Barbara, what I would say is, if as long as if you're writing from sources that are verifiable, I think that the risk of that kind of claim is relatively low.
Hmm.
Mm. The risk for
Although
mother-son relationships, though, is higher.
that's of course key. That's right. Yes.
Yeah.
Thank you. Thank
You're
you.
Even though
welcome.
your husband would most likely back you up, and other people would back you up, and siblings would back you up. The biggest question for me in being a support to you right now is how do we preserve and secure and keep safe the relationship you have with your sons so that you can continue to be, a mother to them and a grandmother to their children and in relationship with them until you take your last breath.
Exactly.
Yes. So
Yeah.
that's a question that a lawyer
Yeah.
cannot answer, Devon. That's
Yes, I'd
Right.
love to be able to answer that question, but that is a non-legal issue.
Yes. Thank you. That's a bigger one. I
yeah,
appreciate it.
for sure. All right, Wanda, go ahead. And Devon, if you want to stop sharing so we can see more of you, that'd be great.
Absolutely, yeah, happy to do that. I forgot that
I
that was
know
happening.
it's so easy. It's so easy.
There you go.
Okay, you Wanda, you're muted.
There, that'll make it easier. I'm not writing a memoir at all. I write fiction,
Okay.
but I'm working on a novel where some of the characters are based on very real people. And I recognize I've changed the names, and I think I have to change the names more because they're too similar. But other than that, what would you suggest? I mean, I'm hoping that the bad guy in the book dies before it's published because then I don't have to worry. But
Right. Well, what I would say is this, right? Fiction is in some ways it's its own ball game, and I think the best thing that I can suggest in your situation, Barbara, sorry, Wanda, is that if you know, lawyers love a good disclaimer, is what I'll say. And so I wonder if in your work it might be appropriate to include a disclaimer that says, this is a work of fiction.
yeah,
Any resemblance to any real person is not intended, that kind of thing. And I mean, there are, we are getting away as lawyers from using sort of template, boilerplate, uh, language in litigation and defamation work these days because it's becoming increasingly complex, but it might be worth it to, work with your publishing and support team and maybe a lawyer to come up with a disclaimer at the beginning of the book that basically just articulates that it's a work of fiction and that any resemblance to any real life folks is purely coincidental.
thank you.
So you're saying that we couldn't use a boilerplate disclaimer that it should be specific to Wanda's book.
I'm not saying that there isn't a place for boilerplate disclaimers. I'm just saying that they've come under increasing legal scrutiny in the defamation space over the last few years. And for what it's worth, it's not just defamation. We're also seeing that in, employment contracts, that kind of thing. That standard form language is becoming less and less useful. That doesn't mean that in Wanda's case it wouldn't be useful. It really depends on the nature of the writing and what the risk is. I mean, if those folks are not particularly easily identifiable or the likenesses are not easily identifiable, then you might be fine with just a standard form sort of boilerplate. I don't think either case, I don't think it would need to be particularly long. The one that comes to mind, we've all seen Law and Order, I'm sure, and they use a disclaimer at the beginning of every episode that says, this is a work of fiction. Any connection to any real life person is purely coincidental and not intended. So
I have another question for you on as a kind of a follow-up to Wanda's question. If the bad guy has descendants, is there any risk to Wanda there? Because she mentioned that she hopes that, he'll die before she's published, right? But if he has any descendants, can they have a right to defamation if there's some way that his family might be identified?
so the short answer is yes. But most of I'll just preface this by saying most of the questions I'm going to answer today will have a but, just so everybody's aware.
Of course.
So I mean, there are instances, or it is conceivable to me, where if the person was to pass away and they had descendants, I think there are certain things that they may be able to do. They might be able to assert defamation claims on behalf of the estate. Um, but they would have to be estate trustees. And, whether or not they would choose to do that, that becomes a fairly uh, labor intensive process because there needs to be estate trustees appointed and those kinds of things. There'll need to be litigation guardians appointed. And in my experience, I'm not saying I've never seen it, but in most cases, once the sort of individual who's the direct subject of the potential defamation is no longer in the picture for whatever reason, these things tend to peter out and sort of just die a little bit.
Okay, good. All right. Hannah, you are writing about a large social agency, kind of not an expose you were saying earlier.
hmm
And
So,
so go ahead.
yeah, so what I'm doing is I have several years connection with Child and Family Services here in Alberta, as a foster parent, as an adoptive parent. And we've seen a declining trend in the capacity for that governmental body to meet the needs of the children in care and the families that are providing that service and truly loving these kids. What I'm doing is from the perspective, sorry, I don't know if you can see me, I'm beside Ginny, but
Oh, okay.
from the perspective of both children that have aged out of care, caregivers, adoptive families, and social workers who have left the field because of the struggles, I have been working to collect their stories and compile them in a way that some might interpret as an expose, but it certainly in many ways may not be a favorable view of the organization, which is CFS. I am anonymizing the participants and presenting the information and the stories in a way that is non-identifying of all people involved. My question is because it is likely, if it gains any audience or momentum, it is likely to certainly paint some of the aspects and functions of CFS in a negative way. Can a government body then come at me for libel at that point? And yeah, that was my first question is, are they able to come at me with a claim?
Yeah, so that's a really interesting question for a couple of reasons. Y- you know, I think, I mean, it- I've ne I've never in my experience heard of an organization asserting libel because I think it's predicated in most of the legal tests that it has to be about an identifiable individual, right? So it may be that somebody from within that organization might sue. Um, but the other thing that I'll say is, especially when you're dealing with governmental bodies, I mean, that to me is probably, especially with all the anonymization you're already doing,
Mhm.
that's potentially defensible as a matter of public interest, right? Um, and there are a lot of very technical arguments about whether or not it constitutes an expression in the public interest, but I would say, especially when we're dealing with governmental agencies and the care or lack of care that they assert over kids. I think my initial reaction as a lawyer is there's probably, even if you were pursued, that's probably something that's defensible under your local anti-SLAPP legislation.
Okay. My next question is that as foster parents, part of the reason why the common public does not know our experiences and the things that we've had to endure when parenting in partnership with a government body is because we all are required to sign oaths of confidentiality.
Yeah.
Now, my question is if we're communicating individual stories in a way that is completely anonymized. Like I'm not even indicating what city or community they're from. I'm just simply telling their story. Uh, does that potentially impact the oaths of confidentiality that were sworn if it's totally non-identifying?
I think if it's totally non-identifying, I think you'd have a hard job being sued for a breach of confidentiality. I mean, again, as a diligent lawyer, I should say that, like I can't give a 100% answer without seeing the confidentiality agreement that you may have signed.
Mhm.
But my initial thought is if it's completely anonymized, then I'm not as concerned. I think that uh it'll depend a lot on the scope of the confidentiality agreement because if the scope of the confidentiality agreement is broad enough, I mean they may have grounds, but I think that it would probably be defensible.
Okay. And then my other question, and I know this because the line I'm walking is somewhat between being an author in the truest sense, but also in some ways connected with a journalistic approach in a way.
Yeah.
Um, is there, as an author, some protection for my sources? Do I have any way of assuring their privacy, or could I be pursued to relinquish information of who my sources were?
So the short answer is yes, you could. And there have been a number of cases in North America, particularly in the United States, where journalists have been ordered to reveal their sources and refused to do so, and they've ended up going to jail for contempt for short or medium periods of time until there's an agreement around that order. So the short answer is I don't see any kind of immediate protection for your sources. However, what I would say to you is it may help you to affiliate yourself with a qualified journalism organization. I'm not sure what the US equivalent is. In Canada, we have the a qualified journalism organization for income tax purposes, and so that may allow you more of that sort of journalistic protection. But if you're a private citizen, I mean, it is possible that you could be pursued to divulge, and then you would obviously have to make a choice as to whether or not you're going to divulge your sources or not.
Mhm. Okay, thank you very much.
You're very welcome.
And I
Wonderful, Devon.
appreciate the information that you've shared.
Happy
Mhm.
to help.
Yeah, and I can actually ask the Canadian Freelance Union if that might be a great place because I know they've worked for me in a couple of cases of clients.
Yeah.
Yeah, so that's awesome. I'll
Yeah.
put Hannah in touch with them as well. Phil, go
Great.
ahead.
I've got two questions, fairly easy from the standpoint of, is there a threshold? Is the threshold high enough to keep away frivolous lawsuits or people that are just trying to get their name in lights to stop some kind of defamation? Is it, I got to write a check for a lot of money for a lawyer, or is the entry fairly simple?
Yeah, so that's a great question, and I would say I think Bill, it depends on where you are. Where are you located?
BC.
Yeah, so what what I would say is this, is that it is it is not difficult to establish at first instance defamation. Um, but likewise, I mean, the courts recognizing that in both Ontario and BC because we get a lot of our defamation law in Ontario from BC because you guys like to make a lot of law about defamation and then share it with the rest of the nation. But what I'd say is um, the threshold isn't necessarily high to succeed on, say, an anti-SLAPP motion if you were confronted with a defamation claim. However, they can be somewhat complex to litigate. So I think your question related kind of more to, you know, what could I expect to pay in terms of legal fees if I ever needed to confront one of these issues? And I think it really depends. It depends on who you deal with. But to your point about what the threshold is, really defamation, whether it's in Ontario or BC and a lot of the US jurisdictions as well, it's not hard to establish prima facie defamation, i.e., that defamation occurred. but um, it's oftentimes relatively simple to defend, and also in some cases to claim public interest protections depending on what you're writing.
Got it. Okay, that's great. Thank you for that. And how do stories like Mommy Dearest, yeah, how do they escape defamation? I mean, that was pretty foul in lots of ways. It certainly threw more than one person under a bus. How did
Yeah.
they escape? Like,
Well, I think there's a couple things that we need to think about in, and I'll use cases like that, maybe not necessarily that specific case, but I mean, the one thing that I like to say is um just because something may be defamatory doesn't necessarily mean that you're going to be subject of a defamation lawsuit for it, right? If you look at, I mean, there are a whole other list of reasons why somebody may choose not to take action on something like that. If, for example, the allegations are hurtful or embarrassing enough that, the fact that they were out there once is a problem, you may sort of do a calculation and say, yeah, I could potentially sue for defamation, but that just brings more oxygen to these allegations because in defending them, I'm going to have to repeat them. So that's one thing. And two, I mean, you know, litigation in general, I would say, is cost prohibitive for a lot of individuals these days. And so, whether or not there were cost implications, I can't say. And I haven't actually done the research. There may have been a defamation suit related to that particular work. But I think, oftentimes the consideration is if I don't like the allegations that are in the creative work, then in defending them, I'm going to have to repeat them, and that's going to embed them more in the public consciousness. So it's always kind of a fine line.
yeah, it's kind of like that herd depth conversation. It just
Exactly.
got messy
That's a
fast.
great example,
Yeah, yeah.
right?
Okay, okay, thank you. Appreciate that.
You're welcome.
Alrighty then. So, Devon, one of my authors who can't be here today, I'm editing his book, and he is talking about the creator of Penthouse at the time that Bob Guccione, however you say that, Guccione, was breaking the law about how much he could portray. And he's talking about it in his own coming of age story. And he's got a really quirky but awesome sense of humor about writing about how, he rented a penthouse in this little town that, and called it, like, wow, I can be in a penthouse and I'm a bachelor and I can get two other guys to, room with me so I can afford it and we can like live the lifestyle of Bob Guccione, the creator of Penthouse. And then he talks about how Bob would take his penthouse models to bed past their playtime, and how so there's actual mentions of the guy of the magazine, and even though this is in the past and this is history and this is common knowledge, what about his tone of voice, the way that he talks about Bob? Is he putting himself at risk?
Yeah, that's an interesting question. I think s- so. Let me answer that question with a overly broad and sweeping statement, and then I'll deal with your question more specifically. I think one of the things we have to think about in when we talk about defamation law is it gets sort of, in my view, inappropriately acquainted with somebody said something that I don't like about me. But that's not really what defamation law is, right? So you you as an individual are to a great extent under the law, and if you live in Canada under the charter, entitled to your freedom of expression. So you're entitled to express yourself how you would. The where you run up against potential defamation concerns is if the information is not verifiable, right? And so if regardless of your tone of voice, if you're sharing your view on a matter that is publicly verifiable, I mean, I don't think there's a lot of risk that that would end up being defamatory because the base things that underlie that opinion, right, w will be verifiable as true, and therefore, likely it's going to be defensible. I think that um, we don't often see courts come back and say it's defamatory because you said something that's true, but you said it in a way that somebody didn't like. The fact of the matter is, if courts can't parse out. I to use an example, and I'll go down a bit of a rabbit hole here, but I often say to my clients, when we talk about technology, right? You can't get a lot of context of how somebody conveyed some information from a text message, right? You just get the words that they said. And so, courts in general, because they are so busy with some very important issues, generally don't like to parse out somebody's tone of voice, right? And it's also very hard to establish after the fact because, again, you know, your words, especially in the context of written word, the words are on the page, right? So it's not like you can use a tone within your writing, but ultimately it comes back to something that's either verifiable or not verifiable. And if it's verifiable as true, then you've got a good defense to any claim of defamation.
Okay. Well, thank you very much, Devon. Just going once. For any other questions, going twice. 3 times.
Excellent.
Thank you
Well,
so much, Devon, for being here, for answering our questions, for being perfectly lawyerly. I like that, Bill. I very much like that. You giving me that statement last year.
I'll take it.
Yeah, it's just awesome that you're in our corner and that you're there if we need you. I will make sure that everybody gets a follow-up email with this, with the link to the video that I'm going to post and
Yeah.
all of your information, which I have, to be able to pass on to them. And we'll continue promoting you because we need you when we are writing truth. There
Well,
are
I'm
people
happy to
that are
be
not going
here.
to like our truth.
There are always people who are not going to like your truth, but that shouldn't prevent you from speaking.
Exactly. So thank you very much. And everyone, one more big round of jazz applause for Devon, and I am so grateful.